This lecture will be devoted in regards to insolvency, bankruptcy, code, and the very future of personal guarantors. So, the Insolvency and Bankruptcy Code 2016 was introduced with the aim to revamp the erstwhile insolvency and bankruptcy laws in India to facilitate and foster the resolution process by lenders against the insolvent debtors in a systematic, effective, and timely manner. The code intended to reorganize and resolve insolvency along with maximization of assets of such debtors with a focus on emphasizing restructuring and not liquidating it at first instance. Since then, the legal regime in relation to insolvency has undergone a paradigm shift, witnessing new horizons. One of the device provisions under the code pertains to the initiation of insolvency proceedings of personal guarantors. Recently, the National Company Law Tribunal accepted the revived application of initiating the personal insolvency proceedings by the India Bulls Housing Finance Limited against the chairman of G Entertainment Enterprises Limited. So, in the capacity of being a personal guarantor, the chairman of G Entertainment Enterprises, Mr. Subhash Chandra, as a personal guarantor to the corporate debtor Vivek Infracan Private Limited, who defaulted on a payment of rupees 170 crore. So, at present, we would like to discuss how a personal guarantor becomes liable. So, a personal guarantor is an individual who has made a promise to assume the responsibility for the debt repayment if the corporate debtor, who is the original borrower, fails to fulfill its obligation to a lender or creditor, as Section 128 of the Indian Contract Act 1872, which deals with the liability of the surety of a principal debtor, states it is coextensive with that of the principal debtor. The apex court or the Supreme Court, while interpreting and examining the term coextensive liability in the case of Industrial Investment Bank of India Limited versus Vishwanath Jhanjhanwala, held that the liability of a surety is not an alternative to the principal debtor, and hence the creditor can initiate the proceeding independent of the fact whether proceeding has been first initiated against the principal debtor or not. A similar view was taken by the National Company Law Appellate Tribunal in the case of State Bank of India, Stressed Asset Management Branch versus Mahendra Kumar Jajodia, stating that the proceedings against a personal guarantor under the code can be initiated by a creditor without any pending proceedings against the corporate debtor. Since the court was still evolving, the judgment of the National Company Law Appellate Tribunal faced criticism and was also challenged before the Supreme Court of India, which reasserted the very decision and order of the National Company Law Appellate Tribunal. So now we would like to discuss exactly how insolvency proceedings would evolve against personal guarantors. So in 2019, the code was amended enabling the creditors to file insolvency proceedings against personal guarantors after various petitions filed in the Supreme Court against the amendment stating it to be illegitimate. It was held in the leading case Lalit Kumar Jain versus Union of India, where the Supreme Court held that the guarantor will be released from its responsibilities and liabilities only up to conditions. One is if the language of the guaranteed contract states otherwise, and secondly, as a result of a voluntary action by the corporate debtor. The petition was dismissed and the apex court declared the amendment to be legitimate. Subsequently, the validity of the amendment was alleged to be unconstitutional and was challenged several times before the Supreme Court. However, in November 2023, the apex court upheld the validity of the provision stating it irrefutably constitutional, putting an end to the widespread chaos and allegations. So, the insolvency resolution process against the personal guarantors as per the provisions under the code in evidently clear from the above that currently there is no such condition precedent that the creditor shall first initiate the corporate insolvency resolution process. Proceedings of a corporate debtor before initiating the insolvency resolution process of its personal guarantor. So, Section 95 of the Code states that a creditor, either on its own or through the resolution, professionals file an application before the National Company Law Tribunal for initiating the insolvency resolution process of a personal guarantor. Once the said application under Section 95 of the Code is filed with the National Company Law Tribunal, the interim moratorium under Section 96 of the Code is imposed upon the personal guarantor. The National Company Law Tribunal, on the basis of the merit, may admit or reject the said application as per the provisions of Section 100 of the Code. In case of admission of the said application by the National Company Law Tribunal, a moratorium under Section 101 of the Code is imposed, in pursuant to which the personal guarantor is barred from transferring, alienating, encumbering, or disposing of any of his assets or his legal rights or beneficial interest therein. Further, no legal proceedings can continue or be initiated against the personal guarantor in respect of any debt during the moratorium period imposed as per Section 101 of the Code. The various impacts that we found, and those impacts on the stakeholders, which may include one as on the creditors. The creditor's confidence is likely to get advanced, proving them with a more financially secure position. As the initiation of insolvency resolution process against a personal guarantor, irrespective of a corporate insolvency resolution process, is initiated against the corporate debtor and will act as an additional tool in the hands of the creditor, and also its impact on the personal guarantors. In the current scenario, the personal guarantors may act with more caution, considering the exposure to the higher risks due to the initiation of insolvency resolution professionals against them on the occasion of default by the corporate debtor, pursuant to which even their personal assets may be delineated and their creditworthiness may be affected. This tends to dilute the concept of corporate being separate from the owners and limited liability of owners to some extent. And another important impact is on corporate debtors. On one hand, the credit environment being supportive towards creditors to initiate the insolvency resolution process against the personal guarantors will provoke them to have more personal guarantees in place while offering credit to the corporates, while on the other hand, the founders will be more conservative and calculative to offer such personal guarantees. This may lead to a situation of cash crunch or inadequacy of funds to the corporates. And now we would like to conclude our discussion regarding the future of personal guarantors under the Insolvency Bankruptcy Code of 2016. So, the code, which was established with an aim to strengthen the economy of India, choosing restructuring over the insolvency of the corporate debtor, affirming the liquidation to be the measures of last resort. The legal landscape in the hour is definitely a proof for creditors. However, it may be a con for the individuals and founders offering guarantees to their companies. It will be interesting to see how the evolving landscape in relation to personal guarantees under the code will be navigate the economy of the country. So, in our next upcoming lecture, we would discuss about those amendments and reforms made to the Insolvency Bankruptcy Code of 2016, and exactly the very statement issued by the concerned minister in the Council of States or Rajya Sabha regarding those 6 important amendments made to the Insolvency Bankruptcy Code of 2016 and almost 122 reforms made to the Act